You're tuned in to Agriculture Today, and we start our Wednesday show talking through some estate and transition planning with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be here today, Shelby.
Roger, you recently wrote an article titled Estate and Transition Planning Potpourri, and one of the things within this article talks about potentially putting farmland in an IRA, and why might that be something that someone does?
Because you have a lot of bad ideas floating through your head, and this is one of those really bad ideas. Don't do it. It's not to say that you can't. You can. But it's really kind of a bad idea because once you put the farmland in an IRA, you really can't do anything about it. You'll trigger a whole bunch of problems if you do, particularly if you want to continue farming the land. You can't do that if it's in an IRA. So, but there are those groups out there that push this concept, and I get questions from farmers. This looks pretty attractive. What I'm being sold here, should I put my farmland in an IRA? Seems like a good investment vehicle, and my answer to that is don't do that. If you do it, you better go into it with both eyes open. And many times the land that you would put in there is financed, and that creates another problem too, because it'll cause the IRA to become fully taxable, which you do not want to have happen. And there's a lot of actions that are prohibited when land is in an IRA.
And when you say they can't do anything on that land, do you really mean nothing?
You can't farm the land. And that's what, if you want to farm the land, do not put it in an IRA. You're going to create a whole bunch of bad tax consequences if you do that. You can't even personally do any work on the land, such as mowing grass or maintaining waterways or painting a barn or doing any maintenance. You just have to keep your hands off. And that's next to impossible for many farmers to do that. You can rent it, but that rent better be based on fair market value. And if you borrow funds to buy the land, as I said, and then you put that in the IRA, you cannot personally guarantee the debt. And so if you do finance the purchase, part of your rental income is going to be, if you rent the land, then some of your rental income is going to be subject to income tax, and the IRA is going to have to file an income tax return. So you have another complication there. And if you put the farmland in an IRA, you're going to have a custodian, an IRA custodian, handle the transaction and the ongoing ownership of the land, and you're going to have to pay fees. The land's going to have to be appraised every year. And then once you turn 73, you may need to partially distribute the land annually. It's just a mess.
So overall, don't do it.
Don't do it. Go take a cold shower and change your mind.
And while we're thinking about different numbers and letters that go along with finances, 401k, and how could someone use that when it comes to farming?
One of the prohibitions that many people find difficult, particularly younger people in getting started in farming, is the capital requirements to start. Agriculture is a very capital-intensive business, and that's a significant drawback to farming on a full-time basis for people. But what I'm saying here in my article is that for people that have been around a while, not necessarily young people, but others that want to get started in farming or expand an operation, for instance, you might already have a substantial asset that you could tap to create that necessary working capital. And that's what I'm talking about. If you have a 401k retirement account, you might be able to use those funds to start a farming business. Now, to do that, you're going to have to create a C corporation to establish a 401k plan in that C corporation and then roll over your current 401k at your old employer into the new 401k plan. And then what happens is that the new plan buys shares in the corporation and becomes an owner. So the money you put into the corporation then becomes the working capital that corporation can use to buy equipment and plant crops and acquire land and livestock, as well as other assets that you're going to farm with.
Are there some legal and tax things that people really need to keep in mind if they choose to do this?
Well, there are. First of all, there's no limit on how much stock in the corporation the 401k can buy. So that means, unlike borrowing money from a 401k, which is limited to $50,000, or cashing in the plan and paying taxes and a 10% penalty on the funds received, that means that you can put a significant amount of capital into the farm business in a pretty tax-efficient manner. So if you do it right and you follow the rules, this can work pretty well. However, There's some drawbacks. You don't want to be overly aggressive with the strategy. The IRS has noted abuses with this concept. So don't think you can set up a corporation simply to buy it. I use an example in my article is you use it to buy a motorhome. Don't do that. You want to use it for business purposes because if you buy a motorhome and you get audited, that's going to be disallowed on the audit. But if you use the cash to create a farming entity and will be actively farming, there's no issue with using a 401k to fund it.
And if someone does use a 401k to fund their farming business and get it started, does that cause issues for maybe passing down to the next generation?
Well, if you do it right and pay attention to the rules, the answer is no. It can be a part of your overall legacy plan, but you have to make sure you stay on top of this to preserve your farming or ranching legacy for your heirs. So if you want to do this, the key with preserving that legacy is don't delay, because we never know how much sand is in the top of each of our hourglasses. And the sooner you get a plan put in place, even if it doesn't include the use of a 401k to fund your operation, the better off you're going to be. And then modify that plan as time goes by because your situation changes, your facts change, your family structure changes, your goals and objectives change. So keep on top of that plan and don't just set one up and have it cast in stone.
And as things are changing, sometimes property that gets gifted, when there's still debt on that property, and when might this be something that happens?
Well, gifting property usually doesn't cause us a problem with respect to a succession plan. In fact, it can be part of a good succession plan overall. Now, it's less popular now than it has been in the past because the federal estate tax exemption is much higher than in the past. So often we don't want to gift property, and that's not the advice to people because you want to, at death, own that property to get a step-up basis in the hands of the heirs. Gifted property doesn't get a stepped-up basis, it has a carryover basis. But you may want to gift for other reasons rather than just tax minimization. You may want to see an heir enjoy ownership of an asset before you're gone. So gifting without debt usually causes no issue for us, but we got the basis carryover issue. But if the gifted property doesn't have a cost basis, and, if you're gifting a line of machinery out, for example, that you fully depreciated out, you don't have a cost basis in it. But if there's debt against that, then you're going to trigger income. So you may still have a loan on a piece of equipment. You've depreciated it out, still have a loan on it because it has value. Now you gift that, and it's got debt on it. You're going to trigger income tax. So let's say that Dad has a fully depreciated tractor that still has $100,000 debt on it. If he gifts the tractor to his daughter, for example, he's going to have to pay tax on $100,000 worth of gain because that's treated as a sale. Now, while Dad could continue to owe the debt, he would need to make sure that he has the income to pay it. So it just creates a lot of complications if there's debt on gifted property. In that example, does it create issues for the daughter? Not for the daughter. It's Dad that's going to recognize the income. The only issue for the daughter is that she's going to get Dad's basis in the tractor, which in my example is zero. So if she were then to sell the tractor, she would recognize gain at that on the full amount of the sale value. What about in partnership scenarios of gifting property? Well, there are many zero-basis farm assets that are held in a partnership. That could include grain inventories, prepaid inputs, machinery, equipment. We could have that in a partnership. But the partnership might also have debt, too. So a gift of a partnership capital account, we got the same problem. That's going to trigger tax on the amount of the negative capital account. Now, what solves that? Death, step-up basis, that's going to solve the problem. That's going to wipe out the negative capital account that can then be gifted to the next generation. So debt, the bottom line here, Shelby, is that debt on farm assets does complicate farm succession planning and can create some negative tax consequences. If we don't deal with debt, if we don't have to deal with debt, it's much easier to satisfy clients' goals and objectives when it comes to succession planning and legacy planning. And as we round out today's conversation and talking about your article, one point in here talking about transitioning the farm or ranch business and a few questions and maybe thoughts if there's not an heir or the next generation to take over. Well, some states have matching programs, and I know there are some informal ways that we do this in Kansas of trying to find a next generation farmer that's interested in farming, someone that's younger, wants to get into farming but can't find a farm. So if you don't want to sell out, if you don't want to put a conservation easement on your farm, and you want somebody to farm it, then there are some programs that you can tap into to try to find that person that could farm and for the next generation. But in any event, when you're transferring to the next generation and your intent is that your operation stay as a farm, make sure you transfer it to somebody that knows what they're doing. We may have multiple children and we want to treat them equally, but when it comes to farming, that may not be the best asset to give them. Give them cash and leave the land and the control to the on-farm heirs, and that goes a long way in solving a lot of problems.
And simply, sometimes also, when you pass on the business, retirement is an okay thing, but might be difficult for farmers and ranchers.
Well, you also need to have an exit plan. The last thing that the next generation wants is your unsolicited advice until you die. So I know that's hard for people in many situations to step aside and watch a son or a daughter take over the operation. But that's kind of an art to it. You got to be able to exit and transition things, and that's important in many situations and can cause problems in some situations if you don't do that.
Roger, I appreciate you taking the time to join us today.
Oh, good to be here, Shelby.
That was K-State and Washburn Law Professor Roger McEowen. I will link this blog article in today's show notes on agtoday.net.